patient. Nelson Mandela's life support did not benefit him at all. He should never have started it. And the doctor-patient relationship is one of trust. And it depends on that healing power depends on the trust. And to me, hastening a patient's death is of significant harm to that patient and to the patient's family. Autonomy or self-rule, we're looking at how do we really make sure that the patient has enough information to make the decision. So the good communication skills. Do our doctors and nurses and healthcare professionals have the time to sit and explore all of these things and to help to make sure that the patient understands the illness and what is going to happen, the trajectory of the illness. And we also have to recognize that there are anyway limits to personal autonomy. That we have to remember that our personal autonomy and personal choice should not compromise another's personal autonomy. So I'm urging everyone here and everyone you speak to be informed. That we don't avoid situations and discussions about death and dying. That people know about palliative care, that we don't avoid hospice or palliative care because we're frightened or because we are not going to go to hospice because that's where people die. Nearly every person, every single person I've spoken to who's come into hospice as a patient says, we should have done this earlier. I could have benefited more if I'd come sooner. And I encourage people to volunteer at your local hospice. You'll see what a place of joy and serenity it is. And you won't think of it as a place of gloom and doom. So you can make those choices for yourself or your loved ones if they want that at the end of life. When we look at justice, the distributed justice, we need to have access to palliative care for all people in South Africa. And our laws should benefit society as a whole. And I just worry about the risk to the wider population of assisted dying is legalized. And they should be carefully considered. There shouldn't be a rush judgment where the case was on Tuesday and the judgment made on Thursday. It really needs a whole lot more consideration than that. So palliative care has been recognized as a human right, and the obligation of our government is to ensure access to palliative care. We presented a petition to the Minister on Human Rights Day in 2012 to ensure that palliative care is accessible, available, and affordable to all South Africans facing advanced illness, so that they are treated with dignity and experience relief of suffering. So the government responded, I'll tell you, currently their access to palliative care, one of these statistics, is really that it's an NGO function currently. It needs to be integrated into the health system. About between 4 and 80% of people who could benefit from palliative care currently receive it. But South Africa was one of the countries who sponsored the World Health Assembly resolution to strengthen palliative care as a component of integrated treatment within the continuum of care. And we are working, the Hospice Palliative Care Association, with the government to implement this resolution. One of the things that it says is that all healthcare workers must be trained in palliative care. Basic training to our nurse and medical students, intermediate training for anybody who works with patients who have life-threatening illness. And I don't know any healthcare worker who doesn't face this at some time. And then specialist palliative care training for people who work in palliative care units or hospitals. So when we come back to our position paper, these are some of the things that we would explore with patients. I've mentioned some of them already. But one of the key things is the timing of the desired death. And quite often people have said, yeah, but I don't want it now. I want it when things get really bad. And what we can do for people in the palliative care sector is make sure things never get really bad, that they're not, people haven't adjusted to it, and they now want that hastened death. So the reasons are hopelessness and depression. As Dr. Kayana said, it's not pain that people are asking for the hastened death. It's people who have got that hopelessness, the depression, and it takes a time to work through that. This last section about people with head injuries and spinal injuries is Harvey Trotchenoff last week. He says they've done work with patients who've had spinal injuries. It takes them about 7 months to have adjusted to their condition and to say, I'm so glad I could not take my own life, or that assisted dying is not available to me. And when I say the risk to the disability community is not our attitudes to the disabled and saying their life is no longer of value and they're not of worth to society. It's them knowing how miserable and how depressed they were when the event happened and how they've managed to come through that and have a really worthwhile life at the moment. And this question of being a burden to others. And I'm going to draw your attention to Giles Fraser, who's a canon at St. Paul's Cathedral in London. And he writes a column in The Guardian that's called Loose Cannon. And he says, I want to be a burden on my family as I die, and for them to be a burden on me. Because when we are this vulnerable, we have little choice but to allow ourselves to be loved and to be looked after. And he says his problem with euthanasia is not that it's an immoral way to die, but that it has its roots in a fearful way to live. So my conclusion here is that assisted dying is an unnecessarily extreme measure, that good pain control is possible with freedom from pain for most cancer patients without distressing side effects from the pain medication, that each person is of value, and that respectful care enhances that value and that person's sense of self-worth and dignity. And that we adjust to changing situations and change our minds about the wish to die. And that our duty as doctors is to heal and to do no harm. So my call is that palliative care is your right, is your choice, and let's make sure that there's better access to palliative care in this country. Thanks very much.
Our last speaker for the evening is Professor David McCoy-Mason, who is a professor of law at the Center for Socio-Legal Studies at the University of KwaZulu-Natal and also advocate of the High Court of South Africa. He is a visiting professor of law. Colleagues, can I just ask if you have to leave, that you do it quietly. He's a visiting professor of law at Strathclyde University in Scotland, as well as an adjunct professor of law at Griffith University. Professor McCoy-Mason has a very impressive bio sketch, but I'm just going to read a few of those. He's a former member of the South African Human Rights Commission Trust, president of the Commonwealth Legal Education Association, involving over 2,000 law schools in 54 Commonwealth countries, and a former vice president of the Academic and Professional Development Committee of the International Bar Association. Professor McCoy-Mason, thank you very much, and ladies and gentlemen, please welcome Professor McCoy-Mason.
Thank you, Chair. When you go last, you've got to pick up the pieces as a lawyer. I think Professor Willem has wiped out sort of a quarter of my speech, and then Professor Dan has wiped out some of the stuff as well. What I want to say, put it in context, and everything the last speaker said, I don't see any of this being in conflict with palliative care. Everybody, palliative care is fine, we need palliative care. There may well be a time when someone says, I don't want any more palliative care. The National Health Act says you can refuse treatment if you want to. The big debate, and this is why, is whether doctors should be actively doing this, and those are the sort of issues I want to look at, because I had another whole presentation on end of life, but then I was in Scotland when this case came out, and I thought I'd better change my whole talk and say something about this case, so that's what I'm going to do. But palliative care, we accept, you need palliative care, it's important, but there is a time, sometimes, when you say enough is enough. And that's what we've got to look at. But let me, I was going to do a whole lot of stuff with you. I'm not going to, because we're going to have time. If you just give me a 5-minute warning because we're not getting there. But what I was going to do was go through the facts. I think you guys probably know that you look at those facts, you will see this person knew exactly what he was doing. He had tried all sorts of alternative remedies. He was on palliative care. He was a highly skilled lawyer. He discussed all the cases. He knew exactly what was going on at the time. So that is a very important thing about the facts of the case. I was going to deal with that, the so-called passive active euthanasia, the paradox, test of unlawfulness. This is the important one because I know that healthcare professionals get very upset when you say legally, and I'll explain it to you just now, you guys actually have the intention to kill patients. The motive might be a good one, but in terms of the law you have, and also you're causing a death. But we say it's not unlawful, therefore it's not unlawful, so it's not a crime to do it. And then people say, but you're equating us to murderers and everybody else, but we're not, because what you're doing is not unlawful under such a condition. Anyway, so some of that I've got to ditch. I'm not going to deal with that. I thought I would just mention this because we heard our chair saying, there's a lot of confusion going on. At the end, I want to just give you a little something about what the legal position is. But the thing about this is that there's not so much confusion because the court was very specific in limiting this, and I'll tell you the implications of it. But the other thing is this, that people said, well, how can you make an order? Someone I read when I was in Scotland said ethics is above the law or something. How can a judge make an order saying you cannot be prosecuted and the disciplinary body of the Health Professions Council can't discipline you? Well, it's not unusual in our law. That Clark case back in 1992 was one, where Clark's wife got appointed as a curatrix and then said, I want to withdraw feeding. And she was worried she was going to be prosecuted. The court said, no, you can't be prosecuted under those circumstances. So it's not an unusual order that was made in those circumstances. The interesting thing in this case, of course, was that the patient died shortly before the judgment. And then people who were opposing it said, well, now it's academic, you don't need to go ahead with the case. And obviously, Judge Fabricius thought this is a very important public interest matter. And so he just declined giving his judgment and went to deal with it. But I'll tell you the implications right at the end. I'll clarify the confusion for you. The one thing you need to remember, and it was made by Professor Willem earlier, the Constitution for us is our supreme law. People fought hard for it, and we've now got it as our Constitution. The ethical rules of the profession can give a higher standard of obligations and duties of health professionals, can be higher than the Constitution, but they cannot take away any rights of health professionals or patients and make them lower than what the Constitution says. So you can have ethical rules which add to those constitutional values, but you cannot have ethical rules that undermine the constitutional values. And that doesn't matter what the World Health Organization, anybody else has said, association, if they try and impose rules which are going to undermine our Constitution, in terms of our legal system, the Constitution comes first. But you'll find in the ethical principles that our last speaker mentioned, most of those are in the Constitution. Every one of them you can tick off as a constitutional value in our Constitution. Okay, a little bit about active and passive euthanasia. As I understood it, what happens with so-called passive euthanasia is you hasten death rather than prolong death. That's the whole purpose of it, supposedly. And we know it's happening every day, and we know when, as Professor Dan said, people are dying all the time through so-called passive euthanasia. So the idea is to allow the underlying injury or illness or whatever to so-called kill the patient. But what has to be accepted, and I'll explain this just now in the law, is that in a way you are contributing, whoever turns off the switch is actually contributing to the death by hastening as such. And that has legal implications, but because it's not unlawful, you don't have to worry too much about it. The other confusion well, let me just say this. How many people here have ever pulled the plug on a patient? It's not unlawful, so you don't be shy about it. When you do that, the lawyers will say that you subjectively foresee, that means so you yourself foresee that if you pull that plug, the patient is going to die sooner than they would have died if you didn't pull the plug, right? And if that happens in law, that says you've got the legal intention to kill the patient. The fact that you're doing it because you want to put the patient out of harm, that's a good motive, and that's why you saw in that Hartman case, the doctor got a very... But that is your motive, and a motive can never make an unlawful act lawful. All it can do is reduce the sentence you're going to get, or you pay less damages or something. Okay, I'm just going to have to disagree. Okay, so we know passive euthanasia is not unlawful. This was an interesting quote that I got from Mason and McCall, who sort of like the gurus in the United Kingdom. They're Scots people, right? They sort of regard the Scots as gurus now, but anyway. This is a very interesting one, because this is what they say in their book on ethics. It was like a throwaway line at the end of the chapter, but I thought it was interesting. When, however, a treatment is discontinued solely by reason of its futility, there's nothing to be lost and much to be gained by intellectual honesty in attributing the death correctly to lawful withdrawal of life support systems which were necessitated by the disease. And that is in accordance with what Bamboa said as well. Those so-called passive euthanasia cases included. So it's really recognizing lawfulness is what makes it lawful. Okay, active euthanasia. The thing about this Stratford Ford case, it's the first time that euthanasia has been looked at within the context of the Constitution in a court case. We all know what active euthanasia is, the doctor's intention to do it. Now, the difference between the passive euthanasia is where technically I said you subjectively foresee. You've got what the lawyers call legal intention. You all heard of dolus eventualis. The story was trial, which got a bit messed up by the judge, but anyway, you all heard about that. But the difference is that in active euthanasia, you have the actual intention. But whether your intention is a legal or actual one, technically you've still got the intention in the law. And that's why Hartman's case, Hartman intended to do it, but the judge was, took a sort of, if you like, a much softer approach. In most of our euthanasia cases, there are not very many of them reported, 3 or 4. All of them, the judges have taken a much softer approach to the sentencing because they realized the motives were the motive can influence them. Active euthanasia and causation. This is the other one, because very often it's said, well, we're pulling the plug, but the disease is killing the person. Okay, so it's not us. Right, but in cases of murder and couple homicide, you don't have to be the sole cause of the death of the deceased person. If one or more events contribute to the death, the event that finally hastens the death. Now, in this case, when you pull the plug, is that hastening the death? Is the death coming sooner than it would have come if you hadn't pulled the plug? And the same way, if there was a fatal dose of medication, again, you would be hastening the death of the person you would have caused. And that's exactly what happened in the Hartman case that was referred to. So really, then, it's a paradox, this idea of active and passive. Clark against Hurst, the judge recognized this way back in 1992. Remember, that was an application to remove feeding from someone who was in the PDS state for 3 or 4 years before that. So, same in this case, this Stratford Ford case. Basically, the court accepted the argument that was found in it. There was a whole thesis that he had to look at this on to say that, again, there's really no difference between the two, and that they should both be regarded as lawful rather than saying one is lawful and one isn't. Because in both of them, whether it's an act or an omission, the effect of that is that you're denying medical treatment, or maybe you prescribe medical treatment which may cause death to become soon. But the other interesting thing about so-called passive euthanasia is they say, well, passive euthanasia is allowing the disease or illness to take over. But when you switch off a machine, isn't that a positive act? To switch off a machine or to withdraw feeding, aren't those positive acts? Not negative acts. So it really is a paradox between how much is done. Okay, legal intention and actual intention. I've been explaining this to you before. Just to say, you heard it briefly from Professor Villen that our court actually, in this case, was very fortunate because the Canadians in February, just a couple of months ago, had a case where the Canadian Supreme Court was faced with a similar situation. They again said, look, this this idea of saying that you've got a difference between the two types of attention and so on, and this idea of passive and active doesn't really make any difference, and it shouldn't make any difference whether you're giving, as long as it is done within proper sort of parameters. As we know, when it comes to so-called passive euthanasia, you don't have to go off to court every day to go and switch off a machine. In the Lamb case in England, the House of Lords, that was a case where a soccer stadium collapsed and lots of people were killed. You've probably seen them having an inquiry now and again. In that case, the House of Lords said they had to go to court if they were going to technically discontinue. But in our case, the courts have just, it's been accepted and people are doing it every day. We're not running every day to go and get a court order. That is the difference between what happened, and I'll tell you at the end now, because at the moment, if you were going to try and do that to euthanasia, you would only do the court order at the moment. We'll get that shortly. Okay. Test for unlawfulness. This is the other interesting thing. In the Clark case back in 1992, the test for whether something is unlawful was the legal convictions of the community. They would be armed. When we got the new constitution, you probably remember our very first case was State against Makanyana. And in that case, I don't know if you remember, but when we had people sending in suggestions for our new constitutional Bill of Rights, there were 2 million submissions. 1 million said keep the death penalty. And the court here, if it had followed the legal convictions of the community, would have said 80% of South Africans want the death penalty, we won't abolish it. The court said no, we can't look at public opinion. We've got to look and see what does the Constitution say. And they interpret the right to life of the Constitution. So this applies to all these other emotional debates that we have. The public gets outraged. The court and the judge in this case said you've got to stand back from your emotions, you've got to focus on what the Constitution says. And so they then took the other interesting thing about the Makanyana case was, you mentioned it, Justice Regan mentioned it, said, you know, life, the right to life doesn't just mean existence. It's okay. Doesn't just mean existence, it means dignity and everything else that goes with it. And that again was what we said in this case, that it can't mean the individuals obliged to live, no matter what the quality of his life is. It's the same in the English House of Lords case, that case said exactly the same. Okay, Dr. Assistant Suicide, we've sort of spoken about that. Just one thing, I don't know if you were there, but I had to chair a session after you guys did your report, right, an audience of doctors and lawyers. And we spoke a bit about that assisted suicide. And the doctors all said, yeah, you would go with it, provided we gave the thing to the patient would take it themselves. Now in law, that doesn't make any difference, because we had a case, John said, if you give somebody a drug to take themselves and you know they're going to kill themselves, you still got the intention to kill them, so it doesn't make any difference. That's how I deal with it. Okay. The thing about this judgment is that the court has been very careful not to make a general rule. It's said that's got to be done by the Constitutional Court of my Parliament. This is a very specific case. So this is just as I see the legal position, and some other lawyers who might disagree. So what he said was each case has to be decided on its merits, which usually happens anyway. And I think the implication here is that it's not a blanket license to go out and do this. I think at the moment, unless you get a court order, I think you're going to be difficult. So my advice to doctors is don't do anything without getting a court order before you do this. Unlike in the case of the so-called passive euthanasia, you can go ahead unless the family or somebody wants to object and they go to court. The court order then can either be some general rules, protocols and things which are done by Parliament, or, as Prof. mentioned, then the Constitutional Court can do it and they can decide what they want to do, because one of their obligations is to develop the common law in line with the Constitution. Another possibility is, and I'm not sure if the Minister of Justice is thinking, I'm not sure they will if they go, but anyway, they can appeal to a full bench in Gauteng, for instance, which would be 3 judges, and 3 judges could look at it, and if they were there to overturn it, there could be an appeal to the Supreme Court of Appeal, and if they're not happy with that, then you go to the Constitutional Court. So there are a whole lot of ways of doing it, unless you can convince the Constitutional Court it's such an important issue, let's go straight to them. So at the moment, It's a decision by one judge. That judge, his colleagues can follow it if they like, can persuade them, they can follow it, they're not bound to follow it. 3 judges, of course, above him can change that decision, Supreme Court of Appeal and Constitutional Court. So it's not really binding in that sense. But what it did do, and this is what was said by him, opens a cause of action to say you guys can go to court, the courts will countenance this. Whether another judge will come to the same conclusion is the same. So the confusion, I think, is don't get alarmed by it. It's not opening floodgates. It's not doing that at all. It's actually giving us an opportunity for what you say is, let's have a proper debate on it. Let's see what happens. Let's see. But I must say, and I'd like to just record this as well, that I thought that Judge Fabricius, you complained all about doing a rush job, but you're doing a rush job if someone urgently wants to do something before he dies, and then decides he wants to die. You have to, sometimes you have to, but fortunately, and I'm quite sure that the applicant himself helped a lot with all this research as well as the people who assisted him. And I thought in that very short time, the judge actually did pretty well craft the judgment, and I'm not so sure that any appeal court is going to come to a different decision. That's not what you say. Right, I think that's it. I've got one little thing that to think about and ponder while you're busy sorting out the candles and things.
As well as Professor Mokokong and Dr. Kurkun, who join us here in front.
Yes, lots. Yes. We never trust to evacuate. That have to leave, if you could just do it quietly. I'm going to open the floor for questions and comments. But before we do that, I wonder if Professor Mokokong, if you would like to make perhaps a 1-minute statement, similar Professor Grootboom.
Thanks very much, Program Director. I feel very great and honored pleased that I was part of this witness. I learned a lot from the discussions that went on. But of course, all we want to know is what is the position of the SPCC. I'm sure that's all you want to know. Now, I can tell you that we guide the profession, we guide the practitioners, and we protect the community. Now, with that motto in mind, we do have guidelines that are called guidelines for withholding and withdrawing of treatment. And all our practitioners are given these guidelines. And I just want to read one sentence so that we can get to other discussions, because this is a statement that we have as of now. Medical intervention where the healthcare profession's primary intention is to end the patient's life is both contrary to the ethics of healthcare and unlawful. This is our opinion. And that's the long and short of it. And this is the opinion that was developed by medical experts in bioethics. The chairperson of the Ethics Committee of the Health Professions Council is the head of this unit of bioethics, the Steve Big. So this is what we as practitioners feel. Thank you very much.
Good evening, colleagues. What I want to emphasize here, I've decided to read what I was going to say and just reflect on what has been said by the previous speakers. I think we need to move away from the concept of active and passive euthanasia. Okay? It confuses a lot of people and it really muddies the waters. Euthanasia, you actively decide. It's a conscious decision. Now, when you decide to artificially prolong a person's life by artificial means, you reach a point which you, with consultation with the team, decide, is this in the best interest of the patient? If the answer is no, the answer is no. You are not intending to kill that patient. Your intention was to give what you think is in the best interest. If the question, the answer then is that it's not in the best interest of the patient, then that's when you withdraw. Right? It's got nothing to do with active or passive euthanasia. It's not euthanasia. The second point I want to make is that I am not a lawyer. I have heard the discussions in this country which took place in the last fortnight about the dictates of the Constitution and the Bill of Rights. What I want to talk about is what is the role of the medical profession in this whole debate. You have heard that the issue of doing no harm and beneficence actually has got a tendency to bring some autocracy in the decision-making of the healthcare workers. Ladies and gentlemen, these are discussions that have been taking place around the world since 1947, after the Second World War. Fortuitously, about a month ago, this issue was brought to the front of the World Medical Association, their ethics committee. The decision was, which is always, it was not done because there is a sudden call from other communities. It was a decision made that all our policies, if they live for 10 years, we need to revise them. The document was circulated throughout the world, 103 medical associations. The decision of that meeting was that, number one, euthanasia is not only unlawful, it's unethical. and so is assisted suicide. And the second decision was that we are reaffirming that standpoint, and our duty is to make our populations aware of this. Okay? Now, the other point that is being made here is the fact that the patient is left in a situation where there is hopelessness. What I think the speaker said tonight is that we need to be doctors. We are doctors, number one, and when that decision to decide that the patient has reached a situation where there's certainty about his death, and any intervention is probably not going to happen. That decision must be done early, and the discussion must involve the patient. It must not be a technical exercise. It must not involve the patient, the family, and all the psychological, psychosocial aspects of the patient must be taken into account, including their spirituality. Because the human being is a complex state. It's a complex animal, okay? And just to wrap up, is that you need to, in your deliberation with your patient, remember one thing, that the medical profession is one of those professions where humanity gave you as a medical student the right to learn from them when they are alive, and also to learn from them when they are dead. Your duty is to heal. Thank you.
Thank you, colleagues. We've heard some very diverse views. Can I ask that you, by show of hands, indicate whether you have a question or comment? If you want to make a comment or ask a question, please can I ask that you do it, that you're very brief, because it means that we can get more questions in. Salman, number one here, I see you had your hand up. 2 over there, 3, 4, and 5, Kevin. So we will take those first 5 questions, and there are some young people running up and down with microphones. So number 1 is over here.
Thank you. I've got 2 questions, one for David before Mason, and one for Liz Green. I thought that the words passive euthanasia are not used anymore. I've been teaching in palliative care for the last, since 1998, when I opened a palliative medicine institute. And passive euthanasia is a misnomer, because the definition between palliative care and euthanasia is one of intent. And palliative care, the intention is to relieve suffering. I'm not talking about assisted suicide, I'm talking about palliative care. The intention is never to actively end a life. It might happen as a side effect, that's double effect. But euthanasia is an active process of deliberately ending a life, which should be legal or not. I'm not talking about that. But there must be a difference. And the word passive euthanasia makes the public confused, because they think they're getting euthanasia when they're getting good palliative care. That's the one thing. The other thing is about Liz. You mentioned terminal sedation. Now, terminal sedation